Robbie Muir, Registrar General of Land, based here in Wellington at LINZ. So my part of the presentation will focus specifically on the aspects of the new regime which impact on the title registration process, but necessarily it's going to overlap a bit with what you've already heard from Samantha and what you're about to hear from Richard. By the end of my session, I hope to leave you with a clear understanding of when the new tax information regime takes effect and the transitional arrangements in place for pre-1 October contracts. Also, a clear idea of when your clients will need to complete a tax statement for property transfers and the information they'll need to provide in that tax statement, but also any exemptions that may apply. I'll also talk a bit about your obligations as a conveyancer and what you need to do to make sure you comply. And we'll take you through some practical advice on how tax information can be submitted via Landonline based on the client tax statements. So I'm going to start with a quick overview of the tax information requirements. So you'll be aware these requirements will come into force as of 1 October. And the relevant amendments to the Land Transfer Act and the Tax Administration Act have just been passed. The new requirements will apply to all transfers of freehold, leasehold, unit titles and licences to occupy. So it applies to transfers. Unless exempt, all parties to the transfer will need to sign a tax statement with their IRD number and provide the other details, and they'll need to give this to their lawyer or conveyancer. So the detail from the tax statement must then be entered for each client in Landonline, and the conveyancer must hold the tax statement itself on file with the A&I form. So the tax statement document doesn't come into LINZ, that's something you keep on file as a conveyancer, but the detail from it is what you enter into Landonline. Tax information must be provided for transfers registered on or after 1 October, unless based on a contract entered into before that date or otherwise exempt. So we'll just walk through this in a bit more detail. So again, for transfers registered on or after 1 October, every transferor and transferee, every buyer, seller, must sign a tax statement and provide this to the conveyancer acting on their behalf, unless it's based on a contract entered into before 1 October and the transfer is registered on or before 1 April 2016. So that's a blanket exemption. If you've got a pre-1 October contract, your client doesn't need to sign a tax statement. And there are two other blanket exemptions. Transfers of Maori land are not caught by this regime. So again, if you're transferring Maori land, no tax statement is needed for any of the parties to the transfer. And the same applies to transfers by the Crown under treaty settlement legislation. So again, in the case of those treaty settlement transfers, no tax statement is needed from any party. So those are blanket exemptions. So if you do need a tax statement, however, what details do you need to provide? So you may have had a chance to look at the form that's provided in the pack, and if you have, you already have a sense of what you need to provide in the tax statement, but I'll just quickly run through this. You've got to provide the details of the property, obviously the computer register number and the transfer details, so the instrument number, the name of the transferor or transferee who's giving the tax statement, whether the property has a home on it, whether the transferor or transferee or an immediate family member is a New Zealand citizen, holds a resident visa, work visa or student visa. In the case of a transferee who holds a work or student visa, or a member of the transferee's immediate family holds a work or student visa, it's necessary to also state whether the transferee or that immediate family member intends living on the land. The tax statement form also provides a place where you can identify any exemption that you may be claiming. So this is where the transfer is non-notifiable for a particular party, and I'll explain this further in a moment. If no exemption is claimed, if there's no non-notifiable category that you can claim, then the New Zealand IRD number of the person who's giving the tax statement needs to be provided, but also where that person is tax resident outside New Zealand, the country name, code and taxpayer identification number for that jurisdiction, as Samantha's already mentioned. And of course the tax statement must be signed and dated by the client who's giving it. So again, all of that information is set out in the tax statement form that's there in your webinar booklet. So what do we mean by non-notifiable transfers? So some transfers may be non-notifiable for a particular party, in which case they don't need to provide an IRD number, but they still need to provide a tax statement with the other details required, and also they need to state the category of non-notifiable exemption that they're claiming. So those categories are the main home exemption that Samantha's already talked about. So where applicable, this can be claimed by the transferor and or the transferee. There's also a non-notifiable exemption for transfers to or from public or local authorities. So where a public or local authority is acting as transferor or transferee, they don't need to provide IRD numbers. They still need to sign off a tax statement. There's also an exemption in the case of transfers of a deceased estate. So an executor or administrator acting as transferor in terms of transferring on that property doesn't have to provide an IRD number, but they will need to provide a tax statement claiming that exemption and provide the other details required. Similarly, in the case of a transfer by mortgagee sale, rating sale or court order, the transferor in that scenario doesn't need to provide an IRD number. So those are the categories of non-notifiable exemptions that apply, and again they're listed in the tax statement form. So just a bit more about the main home exemption. Samantha's talked a bit about this. Main home, the expression main home is defined in the new legislative provisions. Essentially main home means for a person the one dwelling that is mainly used as a residence by that person, and with which the person has the greatest connection if they have more than one home. So that's really the statutory test for whether or not you can claim that main home exemption. So who can claim the main home exemption? Well, it can only be claimed by a transferor or transferee who is an actual person, not by a legal entity such as a company. Can't be claimed by a transferor who has relied on the main home category for other property transfers at least 2 times within the preceding 2 years of the date of that latest transfer. As Samantha's mentioned, it can't be claimed by a transferor or transferee who holds or will own the land as trustee, and the main home exemption can't be claimed by an offshore person either. Samantha's already taken you through the definition of what an offshore person is. So just to reiterate, in the case of those blanket exemptions that I mentioned earlier, no tax statement is required. So that again applies in the case of pre-1 October contracts, Maori land and transfers in connection with treaty settlement legislation. So I'll just mention a few points to note about trustees in particular. If you're acting for a transferor or transferee who is transferring or taking title as a trustee, they must provide a tax statement unless otherwise exempt, and they cannot claim the main home exemption. This applies even where the transfer is only for the purposes of a change of trustees. It's also important to note that it's the IRD number for the trust that's required, not the trustee's personal IRD numbers. So if the trust doesn't already have an IRD number, as Samantha's mentioned, it'll need to get one, and this applies even if the trust is non-income earning. So how will these requirements apply to offshore persons? Again, the offshore person is defined in the Act, and Samantha's taken us through that. An offshore person will need to provide a New Zealand IRD number, as mentioned, as well as providing the taxpayer identification number for the country in which they're tax resident, along with the name and country code for that jurisdiction. As Samantha's mentioned, in order to obtain a New Zealand IRD number, they'll have to have an operating New Zealand bank account, and an offshore person cannot claim the main home exemption when buying or selling property in New Zealand. So what does all this mean for you as a conveyancer? Well, obviously, as part of undertaking the conveyancing transaction on behalf of your client, you'll need to confirm whether or not a tax statement is required or whether an exemption applies. You'll need to obtain a tax statement from every client who is required to give one, and you'll need to hold that on your client file for 10 years, so the same retention period as for an A&I form. When your client prepares the transfer, when your firm prepares the transfer in Landonline, before you certify, you'll need to ensure that all the relevant tax details have been entered in the system according to the details provided in your client's tax statement. It's important to note, however, that you are not certifying as to the validity of the information provided by your client. That responsibility rests with them. So just a few comments about the mechanics of all of this, and in particular, where can you find the tax statement form? The form has been devised in consultation with the property law section, and we do now have a printable version of the tax statement form available from the LINZ website, so it's there for you to print off and use already. And again, an example is provided, I think, at page 11 of the webinar booklet. And you may have already received a copy of that tax statement form in the email that LINZ did out to all Landonline users a week or so ago. We've also made some changes to Landonline with new screens to support the collection of this tax information, and those new screens will go live from 28th of September. So obviously you're not required to enter anything from that date, but they'll be there available in the system ready for the 1 October go live date. Those Landonline changes will also include the ability to prepare and print tax statements from the Landonline application. So this is something you'll be able to do in Landonline as an adjunct to preparing the authority and instruction form for your client. And when you use the Landonline tax statement template, obviously that will pre-populate with your client details, and it means that the details that have been entered in preparing that tax statement are already captured there in Landonline for when you submit the transfer. The new screens will therefore allow you to enter IRD numbers and the other relevant details or exemptions that are required. So we mentioned before these transitional arrangements for pre-1 October contracts. How do you get that information in Landonline so the system knows that you don't need to provide a tax statement details? The way this works is that if a transaction has settled before 1 October, you can enter the settlement date in the Landonline settlement date field, and it necessarily, you may have already done so, it necessarily follows that the transfer is exempt, as the contract date must also predate 1 October. So that if you set up the transfer in Landonline, provided a pre-1 October settlement date, the system will already know no tax information details are required. If the transfer settles on or after 1 October but is based on a pre-1 October contract, you'll need to select the pre-1 October exemption reason from the new Landonline tax screen before you certify. So it's important to remember that. And as Samantha's mentioned, these transitional arrangements will only be available until 1 April 2016. So what's this going to look like in Landonline? I'll just take you through a few screenshots to give you an idea of how tax information will be entered. First, to access the new tax information screen, a button will display at the foot of the Prepare Transfer screen in Landonline. So this will be a new feature that you'll see in the system from 28th of September. And that will then allow you to enter the tax information according to the details provided in your client's tax statement. So the screen effectively steps you through the details that you'll need to provide. And when all of those details have been entered, the system will effectively check that that's occurred, and that'll be noted. For image-only transfers, it's a little bit different. The screen will provide the ability to insert names and effectively the names of the parties that you're acting for, and those names will need to be entered before the tax information can be entered in the system. And this is necessary, of course, because the names of the parties cannot be pre-populated for image-only documents. Of course, for most transfers, this won't be an issue, so this is really an exception. But if you do encounter one of these image-only transfers, you'll need to, again, enter the names of each transferor or transferee that you're acting for. For mortgagee sales, the transferor will be left blank. For transfers also granting an easement, you'll need to indicate the names of the parties who are involved in the part of the transfer that's dealing with the transfer of the property. So if alongside that there's a grant of easement occurring, the parties to that easement obviously don't need to provide tax information. So the way that you can exclude them is just by ticking the names of the parties who are involved in the actual transfer of land. At signing, once all of the relevant details have been entered, the system will run a check to make sure that all the necessary tax details have been provided. And as part of the signing process, after completing your certifications, the tax details for your client will display for confirmation. So there's a checkbox that you tick to confirm that those are the correct details, and then you complete the signing process. So relatively straightforward, but what happens if you make a mistake in that process? Well, if after registration you discover that you've made an error when entering that information, you can lodge a correction e-request via the Landonline system. If the information in the tax statement itself was incorrect, you'll obviously need to obtain a corrected tax statement from your client and hold that on file. It's important to note also that this correction process should only be used where the information was incorrect at the time it was submitted to LINZ. So if there's a subsequent change of circumstances for your client, you don't need to update the tax information on that basis. It's only when there was an error at the time of submission. The other important thing to note is that there are penalties for knowingly providing false tax information. So obviously this is not going to apply to an innocent mistake, but it is an offence to knowingly or with intent to deceive give a tax statement that contains false or misleading information, and you'll see the monetary penalties there in terms of possible fines that can apply. So what will LINZ do with all of the tax information that we collect under this regime? Well, the legislation requires LINZ to supply the information to the Commissioner of Inland Revenue, as Samantha has mentioned, for tax compliance purposes. But as stated in the Act, it's important to note that this information doesn't form part of the Land Transfer Register, so it's not public. It won't be made available for the public. It'll just be provided on to Inland Revenue. The legislation does, however, make provision for releasing information in aggregate form, so for example statistical information, but only in a way that doesn't identify individuals or individual transactions. So obviously privacy was a prime concern around these provisions.